Have you ever been handed a contract and felt overwhelmed by the legal language? You're not alone. Most people glance through agreements and sign without fully understanding what they're committing to. But lawyers, they read contracts differently. Today, I'll show you exactly how to read a contract like a lawyer, step by step, so you can protect yourself, make smarter decisions, and avoid costly mistakes. Let's start with something crucial. Don't skip the beginning. Every contract starts with what's called the preamble or introductory paragraph. It usually includes the names of the parties, the date, and a brief description of the purpose. Lawyers read this section carefully to make sure the correct legal entities or individuals are listed. For example, if you're signing on behalf of a company, make sure the company's full legal name is used, not just a nickname. If this part is wrong, it could make the entire contract unenforceable. Next, lawyers move on to definitions, and they don't skip a single one. Most contracts have a section labeled definitions or interpretations. These might seem boring, but they are critical. A single word like services or confidential information might have a very specific meaning in that contract. Lawyers will read each defined term and highlight it. Why? Because the word might look familiar, but its definition in the contract could be totally different from what you assume. And these definitions are used throughout the entire agreement. Now comes the heart of the contract, the operative provisions. This includes the terms of payment, responsibilities, deadlines, and deliverables. Lawyers dissect each clause here. One powerful trick they use is to break down long sentences into smaller parts. Legal sentences often have multiple conditions and subconditions, and lawyers mentally, or literally, number each clause. This helps identify if something is missing, unclear, or gives one party too much power. Let's take an example. Say the clause says, "The vendor shall deliver the goods within 30 days, provided that all conditions are met, and if not, the buyer may withhold payment unless otherwise agreed in writing." That's a lot to unpack. Lawyers would break this into: what are the vendor's responsibilities? What are the conditions? What happens if the conditions are not met? Is withholding payment the only remedy, or are there others? And what does "unless otherwise agreed" mean in practice? See how a single sentence can carry layers of meaning? Then there's the boilerplate, the stuff at the end most people ignore. Lawyers don't ignore it. This is where you find clauses like governing law, entire agreement, force majeure, severability, and amendments. These clauses may seem standard, but they can drastically affect your rights. For example, a governing law clause tells you which state or country's laws apply to the contract. That matters, because laws vary. If there's a dispute, where do you go? What if you're in Texas, and the contract says New York law applies? That changes everything. Lawyers also zero in on termination clauses. How can the agreement be ended? What notice is required? Is there a penalty? Can either side walk away easily, or is it one-sided? These details are often buried deep in the contract, and if you miss them, you could be stuck in an agreement longer than you expected, or face financial penalties for ending it. Let's talk about red flags, things that instantly get a lawyer's attention. Vague language is number one. If the contract says something like, "Party A shall use reasonable efforts to deliver the services," that's open to interpretation. What's reasonable? A lawyer will either clarify it or ask for more concrete terms like deadlines or performance metrics. Another red flag is one-sided indemnity clauses. Indemnity means one party promises to cover the losses or legal costs of another. If the contract says, "You agree to indemnify and hold harmless the other party for any and all claims," that could put you on the hook for things that aren't your fault. Lawyers flag this and often negotiate mutual indemnities or limitations. Speaking of limitations, lawyers love a clause called limitation of liability. This limits how much one party has to pay if things go wrong. If the clause says, "In no event shall our liability exceed the amount paid under this agreement," that sounds good for them. But what about you? If their failure costs you $50,000 and the contract only covers $5,000, you're out of luck. Lawyers look for this and consider how fair it is based on the risk. Another tool lawyers use is cross-referencing. If a clause says, as described in Section 7, they don't just trust it. They flip to Section 7 and check if the reference is correct. Typos, mislabeling, or inconsistent clauses can lead to confusion later. And if a conflict arises, courts will often interpret contracts strictly. One more thing lawyers always do. They think in worst-case scenarios. While most people read contracts assuming everything will go well, lawyers ask, what if it doesn't? What happens if the other party doesn't pay? What if deadlines aren't met? What if there's a breach? What rights do you have to recover losses? Can you terminate the contract quickly or take legal action? This mindset helps protect you before anything even goes wrong. Now let's address a common myth. Length doesn't equal strength. Just because a contract is short doesn't mean it's simple. And just because it's long doesn't mean it's strong. Lawyers know that some of the most dangerous contracts are the shortest because they leave too much unsaid. So even if it's a one-pager, they'll scrutinize every word. Finally, lawyers always read the contract more than once. First pass, they get a general idea of the structure. Second pass, they go clause by clause. Third pass, they look at the entire agreement in context. Does it reflect the deal both sides agreed to verbally or in emails? If something is missing, vague, or inconsistent, they ask for clarification. And they never sign a contract with blanks, unexplained attachments, or handwritten edits unless they are properly initialed and agreed to. In summary, if you want to read a contract like a lawyer, here's what to do. Start from the top. Read the preamble and definitions carefully. Dissect the operative terms. Break long sentences into parts. Read the boilerplate. Don't ignore the end of the contract. Watch for red flags, vague language, one-sided terms, indemnities. Think like a pessimist. What if something goes wrong? Cross-reference sections and double-check all clauses. And most importantly, read it more than once. Contracts are not just paperwork. They're legally binding promises. When you read like a lawyer, you're not being paranoid. You're being smart. You're protecting your time, your money, and your future. Thanks for watching. If this helped you understand contracts better, don't forget to like, comment, and subscribe. And remember, never sign what you don't understand.